Hello everyone, my name is Hassan Adnan Khan and I am an overseas student of University of Hertfordshire, and here's my ID card. This presentation provides legal advice to Bob Decor Limited regarding detective furniture delivery supplied by Wood Create Limited. The presentation examines Bob's rights under the Sales of Goods of 1979 Act, especially whether he can reject the good already delivered, whether he can determine the remaining installment of the contract. On 10th May, Bob Decor Limited entered into a contract with Wood Create Limited for the purchase of 12 oak dining tables measuring 1.5 meter each and 16 wooden chairs packaged in box of 10. The parties agreed that delivery would take place in 3 equal installments on 20th, 23rd and 26th of May. Payment was to be made 1 week each after installment was delivered. These agreements therefore constitute an installment contract, making Section 31 of Sale of Goods Act particularly important. And the first delivery contained several defects. Instead of 4 oak tables measuring 1.5 meters, Wood Create supplied 5 ash tables measuring 2 meters. Only 15 chairs were supplied rather than 20. The second delivery was also defective because only 2 tables and 15 chairs were delivered. The second delivery was also defective because the repeat nature of this defect is legally significant because it may justify determination of entire contract. They have a contract of 20 tables in the particular times, but they delivered only 15 tables. That's a misconduct of an agreement. The first legal issue concerned Section 13 of the Sale of Goods Act 1979. This section provides that goods sold by description must correspond with description. Bob ordered oak table measuring 1.5 meters. However, the ash tables measuring 2 meters were delivered. This leading authority is Decor Limited versus Renaissance, where the House of Lords confirmed the buyer may reject goods that do not correspond with constructional descriptions. Applying that principle here, both material and dimension differs from the contract. Therefore, Bob has a strong legal right to reject the tables. Section 30 addresses situation where the seller delivers the wrong quantity. Each installment should have contained 20 chairs, instead only 15 chairs were delivered in both occasions. The law generally allows a buyer to reject goods where there has been a short delivery or a short time from a delivery time. As a result, Bob is entitled to object the both deliveries and rely on Section 13 as a basis of rejection in the agreement, as per the agreement. An additional issue concerned packaging. The contract specifically stated that the chairs would be packaged in box of 10. In R.A. More versus Landlord, the court held that good could be rejected even where the quantity was correct because the agreed packaging requirements has not been followed. It has a very strict law in the Section 13 of Goods Act 1979. Similarly, Bob contract the chairs packaged in a specific manner. Therefore, the packaging defects provides an additional grounds of rejection. Considering Section 13 and 30 together, Bob has a strong grounds to reject all the goods delivered so far. The table do not correspond with their descriptions. The chairs were delivered in insufficient quantities and were incorrectly packaged. There is a very strong law in the dishonesty of a agreement or a packaging of a incorrect packaging. The chairs were delivered in insufficient quantities and were incorrectly packaged. As Bob has identified the defects promptly and has not accepted the goods, he retained his rights to reject. This is the most important issue of this assignment, that the Section 31 governs installment contracts and provides that a defect in one installment does not automatically determine the whole agreement. The leading authority is Maple Flock versus Universal Furniture Products. The court stated that termination depends on the seriousness of breaches and the whether the future performance is likely to be defective. In this case, two consecutive deliveries contain subsequently defects involving description, quantity, and packaging. This pattern suggests that Wood Create Limited is unable to perform the contract properly. Consequently, Bob has a strong argument that he may terminate the contract and refuse the third-party delivery scheduled on 26th of May. The final legal advice that I want in the conclusion, that the Bob is entitled to reject the tables because they fail to correspond with the constructional description under Section 13. He may also reject the chairs because the quantities applied were insufficient and the packaging requirements were breached. Finally, due to the repeated defects across two installments, Bob has very strong grounds under Section 13 and Maple Flock to terminate the contract and cancel the final delivery of 26th May. Here is the bibliography of primary sources of this assignment: Sales of Good Act 1979, Arcos Limited versus Hassan and Son 1933, AC 470, Hong Kong Fire Ship Co Limited versus Kawasaki Kaisen Kesha Limited 1962, Pamel Flock Co Limited versus Universal Furniture Products Limited 1934, Remore and Co Limited versus Landlover and Co Limited 1921. The secondary sources are Bridge M, The Sale of Good, 5th Eden, OUP 2021. McIntyre E, Contract Law 15 EDN, Macmillan 2024. And here is the ending of my assignment with the conclusion that Bob is entitled to reject the tables because they fail to correspond the contractual description under Section 13, and he also rejected the chairs because the quantity supplied was insufficient and the packaging requirements were breached and they were not properly in the first and second installment. Both times the packaging were not correct by the Woods Limited. Finally, due to repeated defects across the two installments, Bob has strong grounds under Section 31 and Pamel Flock to determine the contract and cancel the final delivery. And here is the end of my assignment. Thank you for listening. This concludes my legal advice to Bob Decor Limited. Thank you. Here is the